Yes, good evening to the All India Bar Examination student, those who sat on the 5th February, the exam, that is the 17th cohort, and yesterday that we dealt the 13th question, but I thought that is the set D, but I found it's not, but it doesn't matter. Only the shuffling would be there, but the questions are the same. Okay, now let us see, shoot the first question. Suppose a road accident occurs, then being an advocate, what is the correct way of approaching the situation? I already posted you yesterday the photo. Which one is the right answer?
Sir, option A, FIR
Option
petition.
A, first FIR, next petition, next summons to the insurance company. That is the sequence. Either he is a advocate or he is any person, doesn't matter. So that is the first is the right answer for this question. Then second question, principle of ubi jus ibi remedium. Ubi jus, I think they committed a mistake. Ubi jus ibi remedium, that then idem is not there, was recognized in dash, a Winterbottom versus and Campbell and the Rylands and the Ashby. Which one is the right answer? Which was the right answer? Second question. Participants, are you hearing me?
Yes, sir, I am hearing, but I don't know, sir.
Actually, you don't know. Okay. See, this answer is, actually, you know the meaning of UB just UB remedium? Where there is a right, there is a remedy. When here the person injury is caused, then he should be compensated. So here injury is caused in Ashby versus White case law, where the injury is caused over him, and hence he should be compensated. Whether the injury is small or not, it doesn't matter. What is that injury? A right to vote is infringed in this case law, even though the person who is voting, to whom that a voter is voting, he won with a bumper majority, but not allowing a voter to elect it, that is the infringement is happened. So Ashby versus White is the right case law. Then Gloucester Grammar School, it is a very famous case law, everybody knows it, I need not to say. What is the answer? Participants, if you don't know, you say pass on, I will give the answer.
Damnum sign injuria.
It is a damnum sine injuria because a damage is caused. Most of his revenue, he lost it. But there is no legal injuries caused to him, hence he is not going to get any compensation. That is the Gloucester Grammar School case law. A, damnum sine injuria is the right answer. And injuria sine damnum, it is the right answer is Ashby versus White, where the legal injury is caused but no substantial damage is there. That is the case law is there. Okay. Now next case law, fourth one is the National Consumer Dispute Redressal Commission under the Consumer Protection Act 2019 shall have the jurisdiction to complaints where the value of the goods or services paid as a consideration exceeds dash. A, 1 crore, B, 10 crores, C, 5 crores, D, 100 crores.
Sir, option B, 10 crores.
Option B, 10 crores is the right answer because according to the new Consumer Protection Act of 2019 is concerned. Okay, fifth question. The text of the certified standing order shall be permanently posted by the employer in a dash and the language understood by the majority of his workmen. What language should be used over there? A, Hindi, B, English, C, Devanagari script, D, languages specified in the 8th schedule of the Constitution. Standing order shall be permanently posted by the employer in which language? Say pass on, I will give the answer.
Pass on, sir.
It is English. English language could be used, not Hindi. Because Hindi will be known on the mostly North Indian people, but standing orders is everywhere the same. And Devanagari script, the language which is written in the Hindi Devanagari script, that will not be known to the people, especially in the south, or southeast.
How is it correct, sir? How language understood by majority of his workmen? How is it correct, sir? How is it possible?
Yes, that's why the English is the right answer. Because generally the English is the link language in India. English is the link language in India. It is an
Okay, sir. Okay.
international language in India. Any state, there is the English correspondence would be there. But they write in the Hindi, they write in Telugu, that is a different. But central acts, it should be taught in English only. So, sixth one, a person who has ultimate control over the affairs of the factory under the Factories Act 1948 is called dash occupier, B, managing director, C, chairman, D, manager.
The occupier.
It is an occupier. Most of the people write managing director. No. A person who has ultimate control over the affairs of the factory, under the factory, it is only the occupier. And who occupies that particular thing. Seventh, if the factory employs more than 1,000 workers and they should appoint the qualified dash, carry out the prescribed duties. Yesterday that we already seen the answer. What is the answer?
Safety officer.
Safety officer. Even I myself also committed a mistake here. I thought it's the welfare officer. Okay, next question. The eighth question. Mr. Manjot is a trader supplying the goods from his Mrs. Singh's traders. The office of the firm is located in Delhi, where its godowns are located in the state of Uttar Pradesh, Punjab, and Jammu and Kashmir, respectively. And Mrs. Singh traders and the following interstate supplies from the different states during the current financial years. Number one, Delhi taxable supplies so and so, and two, Punjab exempted supplies so and so. 3. Uttar Pradesh taxable and exempted supplied so and so. And 4. Jammu and Kashmir taxable and exempted supplied so and so. And the ascertain the state in which the Manjit is required to take the registration and the GST. Where he has to take the registration and the GST, especially A. Delhi, Punjab, Uttar Pradesh and JK. B. Delhi, Uttar Pradesh and JK. C. Delhi and Uttar Pradesh and D. Delhi. See, when you are paying the GST, location is important, or from the where you are getting the goods is important. Two places are important here. Where the godowns are placed is important, or location is important. Here they said office of the firm is located in Delhi. Yes, this is important factor. Whereas its godowns are located in the state of Uttar Pradesh, Punjab, and Jammu and Kashmir and JK. So, what the GST says, and here they have given the right answer is Delhi, Uttar Pradesh, and Jammu and Kashmir. That is the answer which is given. The right answer. Punjab is not there. Let me check the eighth answer. Once again, to key the eighth answer. B. Eighth answer is set D. Answer is B. Is it clear? I don't know why Punjab is okay, doesn't matter. It's the one mark, it doesn't make any difference. Okay, ninth. The primary GST slabs for any regular taxpayer are presently pegged at. Okay, this also we cannot make it out. Let it goes. But the right answer here is
C. C, sir.
it C?
Yes, sir.
Let me check it. Ninth answer C. Yeah, ninth answer is C. Yes, sir. It doesn't matter. It is 0 point because we cannot predict it. It's very difficult to predict also. So we can leave it. It doesn't matter. Under the section 41 of the Consumer Protection Act 2019 and an appeal from the District Commission to the State Commission or the Consumer Tribunal or National Commission. This is an easy question. Yes, what is the answer? What is the answer for the 10th question?
Sir, State Commission?
It is from the district commission to naturally it goes to the state commission only. Because when the district is there, what is the question? They said, 10th question. A. State commission only. From the state commission it goes to the
National Commission.
National Commission, not the High Court. They thought that people will write the High Court. They thought that the people will write the High Court. No, they know it. Yeah, for an individual to be demanded to be the resident in India in a previous year, one of the condition is if he is in India for a period of 182 days and more during the previous year. Oh, the tax, regarding the tax is concerned. Okay, if he is in India for a period of 180 and more during the previous year, and if he is in India for a period of 181 days, more in India and 360 days. Oh, he framed the question in my style. I am sure that we can shoot it now.
Yes, sir. A 182 days, half year.
So, in general, what is that? Is it 1 year completely or 180 days? The question. 11th
No, sir. Half year, 182 days.
11th year, yeah. It is 182 days. More is enough. A is the right answer here. A is the right answer here. Is it clear? So now the 12th question. Mr. Kapoor purchased a resident house in January 2021 for the T 80,000. I don't know what is T here. Taka or something. He sold the house in April 2022 for the T 94. In case of the gain of the, is it I or T Indian rupees? T 14,000 assigning the sale of the, is it taxable income? No, not taxable. Residence house and will be charged to tax under which the following head. Income from the capital
Sir, I
gains.
think it is
We
printed
already said
wrong
it.
in
It is from the income from the capital gains.
Yes, sir. I think it is printed wrong in D set
No,
only.
no, no, no.
He is
Because
not there in by D set.
when he converted from the doc file to, in the PDF file to the doc file, sometimes the numbering will be changed. And the T's or rupees will be changed. Yes, I know it. It is changed from the PDF file to the document file. So, according to Section 5 of the Specific Relief Act 1963, a person entitled to the possession of the specific immovable property may recover it in the manner provided in the Specific Relief Act, the Code of Civil Procedure, the Code of Criminal Procedure, the Transfer of Property Act. I don't think it is a tough question. See, manners will be given in the civil cases where participants.
Sir, Usu factory, sir.
Yes?
Option D, Usu factory. Usu factory.
Here I am speaking in this 11th question. I am speaking this the 13th question. In Civil Procedure Code,
Sir,
it will
I
be
wrote
done because
Specific
it is a
Relief
civil
Act
case.
1963, sir. Sir,
Yes?
I wrote Specific Relief Act 1963.
No. Because Specific Relief Act are there, no doubt. How the property will be made or confiscated or position or recovery. But procedure will be shown by the Civil Procedure Code because it's a civil case.
Sir.
Am I right?
Yes, sir. Yes, sir.
The procedure will be shown by the Civil Procedure Code. If it is a criminal act, it will be shown by the procedure will be seen by the Criminal Procedure Code. Is it clear? So the right answer is the Code of Civil Procedure is the right answer here.
Yes, sir.
Okay, 14th question. Where the mortgager delivers a position of the mortgage property to the mortgagee and authorizes him to retain such position until payment of the mortgage money and to receive the rent and profits accruing from the property in the lieu of the interest in the payment of the mortgage money or a transaction is called a dash mortgage. Which type of the mortgage it is? 14th question.
Sir, option D, Usu factory.
Yes, where the mortgage delivers the position of the mortgage property, mortgagee and authorize him to retain the position of the until payment of the mortgage money and to receive the rents. Yes, it is a Usu factory. Let me check it. No, not necessarily checking. It's the 14D, usufructory, because you will enjoy the rents. So now 15th question is, in which of the following cases it was decided that a contract with a minor is a void? And everybody knows. Yes. Give me the answer. A contract with a minor is void. So famous case law. Participants, say pass on. Yes, Lakshmi.
Sir,
You
Carlyle
don't, you
was
know,
I
you
wrote
don't know.
Carlyle versus carbolic smoke balls, but it not correct, sir.
It is a unilateral contract that is a.
Yes, sir. Yes, sir.
It is a unilateral contract. The famous case lies Mohri Bibi versus Dharmdas
Also, in
Ghosh.
that case, God's act also is there, sir.
Yeah, Mohri Bibi versus Dharmdas Ghosh is the right answer. Is it clear? Okay. Now the 16th question. B. The proprietor of the newspaper publishes a request, a label upon C in the paper, and A agrees to indemnify the B against the consequences of the publication as are all costs and damages if any action in respect thereof. B is sued by the C and has to pay the damages and also incurs the expenses. Decide the highest. The light of the section 224 of the Indian Contract Act 1872, A is not liable to be upon indemnity, B, A is liable to be upon indemnity, and C, A is not liable to upon indemnity, none of these. Okay, to me also is tough, but I don't know. You
Sir,
can shoot
option
it.
A is not liable to upon B indemnity because it is under light of the 224.
Okay. If it is, you don't shoot also doesn't matter because after all we left only four till now. After all, we left only four. Okay. Any person whom the agent names the act of the principal in the business of the agency, then the express or implied authority, the name is called sub-agent, agent, substitute agent, a procured agent. Name of the fundamentals in the business agencies under the express or implied authority. I think the sub-agent.
Sir, sub-agent is correct. Substituted agent is correct, sir. I also wrote sub-agent, but it is wrong in according to the P.
Okay. Now let us see that. Doesn't matter. Sub 17B is the right. Substituted agent. Okay, but thus we have to just careful about it. Business of the agency and the express or implied authority to name substituted agent. Okay, it doesn't matter. Only 5 marks will be left. And next question is 18th question. A dash in this is a very easy question. A dash injunction can only be granted of the degree made at the hearing and upon the merits of the suit. The difference is thereby perpetually enjoined from an assertion of the right of from the commission of the act, which would be the contrary to the right of the people. See, one after the hearing of given means nothing but
Perpetual.
perpetual it is. There is no other, he cannot confuse it. He should have confused in a different style. Okay. Next 19, the specific person under the right to fair compensation and transparency in the land acquisition, rehabilitation, there is a resettlement of the Act 2013 means any person other than dash. I shooted it without looking at it. I shooted D is the right answer.
Yes, sir, correct.
Because I did not see the answer actually when I was going through it. But later I saw the action. I suited it. It is all of these. Then I checked the answer. It is all of these. 19D. See, 19D is all of this. See, I used my intelligentsia. I said, why this fellow give all of these? In other places he did not give. Am I right? Am I right?
Yes, sir.
In the upper places he did not give, but here he specifically gave. I said, no, shoot this one. So, 20th question. Who shall the register of the trademarks for the purpose of the Trademarks Act 1999? A. Controller General Patent Designs and Trademark. B. Controller General Copyright Designs. I think we asked the question this one. Is it not? In the what is the full form of this one? I told you. The Director General of the Patent and Designs and Trademark and the Director General of the Copyright and Design and Trademark. M, is it DM or C? C, CM. So which is the right answer?
Sir, I wrote G and DG, but it is a Controller General of
See, first
Patents,
comes
Designs and
patents,
Trademarks.
next come designs, next come trademarks. And he followed the different style here. First come patents, next come designs, next come trademarks. Only two places are there. See, Controller General of Patent and Director General of Control. And I told you CGMPDTM, the acronym, the initialism I have shown you on that day.
Sir,
I showed you the
I remember
the
little, but I
initialism.
wrote Director General instead of Controller General.
Okay, doesn't matter. Doesn't matter. Only 6 marks you lost. No matter. Which one of the following is not a type of IPR? Copyright, patents, designs, historical indications. It's an easy question.
It is very easy.
Yeah. One easily can make it out without. The answer is D. Because we do have geographical indication, not historical indication. Is it clear?
Yes, sir. Yes, sir.
Okay. Then. Which of the following are the correct with respect to the declaratory decrees under the Specific Relief Act 1963A? Section 34 of the said act deals with it, and it is the discretionary in nature. C, both section 34 and the act deals with the A and the discretionary in nature, and none of this. I should see.
Yes, sir, I don't know this, sir.
I should see. I don't know. 22. Is
Sir,
it
I also stated C, but it is wrong.
22C? 22C, right? I am.
I am also ready, sir. Right, sir.
Yeah, I am right. See, I used my only permutation combination. Why this fellow asked the critically here? Perhaps this may be the right answer. So I shoot at C. Okay. Now, which of the following is not a negotiable instrument defined under that? This is an easy question. Act 98. Promissory note is an instrument. Bill of exchange is an instrument. Check is an instrument. What is not?
Billing report, billing receipt.
Yes, that is not. Now, some of them ask very easy questions. I don't think that one should ask like such question because everybody knows. He can ask check bounce cases under which act, which section it will be dealt in the negotiable instrument. A bit that is a little hard question. Okay, anyway, 24th. According to the rights to fair compensation and transparency in the land acquisition, rehabilitation, and resettlement 2013, appropriate government can acquire the land for the which of the following purposes? I think public purposes, is it not? Strategic purposes related to the naval, military force, and armed forces of the object of the water harvesting of water. Project for the harvesting of water, yes. Conservation structures and situation, it is jumbled over there. Project supports the healthcare, tourism, and transportation and program. And here he has given 1, 2, 3, B 2, 3, 4. Oh, my style, he adapted 1, 2, 3, 4, and D is 1, 2, 3, 4. They said not. According to the right to the Fair Competition Act, appropriate government acquire the land for the which of the following purpose. No, all of them. D is all of them. I should D all of them. 24. 24. D, all of them. Is it clear? Participants, say yes or no.
Yes, sir.
Yeah, please give the answer. Even one student also there, I will teach the class because I promised I would like to keep my promise. Yes, in which one of the following cases the Supreme Court decided that the constitutional amendment is the law within the meaning of Article 13.2 and therefore it is a violation of any fundamental right may be declared void. Sajjan Singh was state of India. Easy question.
Sir, this is Golaknath case, sir. I know it perfectly.
See,
After Golaknath case, Keshavananda Bharati case came, no, sir.
yeah, Keshavananda Bharati case, no, wrong. Indra Sahani case, it is about the reservation. So either is a Sajjan Singh case or the Golaknath case. Only two. So
Golaknath case is right, sir. After Golaknath case, only judgment is reversed by the Honorable Supreme Court to bring Keshavananda Bharati case.
Yeah, you are right. Your logic is very right. Your logic is very right. It's a Golaknath case only, then it is changed the way. So, uniform civil code in India is a fundamental right, a direct principle of state policy, government policy, a constitution. It is a B is the right answer.
Yes, sir. Direct to principles.
Because there is a whether there should be a common policy should be there. Shall we check it or need not to check it? 26. Because they specifically mentioned 26. Yeah, B. Right. We can shoot it. Yeah, next is the 27th question. As per the Article 16, no citizen shall on the ground of dash or any of them be ineligible or discriminated against the respect of any employment or office under the state. Oh, he adapted the best method. Religion, race, caste, descent, place of birth, residence. Religion, age, caste, sex, descent, place of birth, residence. Religion,
Sir, in all
race,
remaining
age.
options, age is there, sir. But actually, age is not in the article. That's why option A is correct, sir.
See, he adopted the my style. Am I right?
Yes, sir. Yes, sir. To confuse the candidate.
Yes, yes. I want to confuse the candidate in that way. So the right answer is
Sir, option A.
26th A, right answer. Okay. 26th A. No, 26B they wrote. 26, not A, B. Can we check it now? Religion, age, caste, sex, descent, place of birth, residence. Religion, race, religion, age. No, let me check it for our clarification.
Sir, option A, right, sir. Age is not there, sir.
Huh?
A is right, sir. Age is not there, sir. Age is one of the rule for employment, sir.
Okay, okay. Now you are right. Now you are right. So option A is the right answer. Is it?
Yes, sir.
Means 27th question. 27th question. A is the right answer. Yes, you are right. Yeah, you are right. Yeah, correct. Yes, that logic you can use it. So the minimum number of judges who are to sit for the purpose of deciding any case involving the substantial question of law as to the interpretation of the Constitution or for the purpose of the hearing the reference and according to Article 143 shall be always odd number. How many?
Sir, I wrote it as 3, but it is 5.
28, right. 28, 5 is right. I say not even number. No 4.
I wrote it as 3, sir.
No 2. But 3 means substantial question. No, 3 will not be there. 5 would be there.
Yes, sir. I wrote as B, sir.
Okay, doesn't matter. Only 7 marks you lost it. According to the article, it's an easy question. 3000A of the Constitution of India number dash shall be deprived of the property save by the authority of the law. Person, citizen, foreigner, Indian.
Sir, Article 393, sir.
And now I am speaking about the 300A.
Sir.
According
Person,
to Article 3000A of the Constitution, India, no person shall deprive of the property save by the authority of law or citizen
Yes,
or foreigner
yes, sir. This
or
is correct,
Indian.
sir. A person is correct.
What? Okay, let me check it. 29A, A is correct. Any person, not citizen necessarily. So he also used my style. Am I right? So the 30th question, the title of the Constitution of India is laid down in Article 1, Article 5, Article 390, Article 393.
Sir, 393 is correct, sir.
Which one is?
393, option D.
Is it? Even myself also doubt this one.
Sir, I checked in Barak's book, sir,
Okay,
in examination.
okay. Even myself also.
Besides student is having
The title
book,
of the Constitution of India is laid down in Article 393. Okay. The Constitution provision of fundamental rights are given under which part of the Constitution of India?
Part 3.
And so easy question it is. Okay, doesn't matter. By which of the following Amendment Act of 1985 anti-defection law was added to the Constitution of India? Yeah, this I taught in the earlier classes.
Yes, sir. Option B, 52nd Amendment.
Yes. Even I also going to shoot this one only because I remember it in my mind. So next 33 questions. Name two essential conditions of the penal liability. One is a guilty mens rea. Is it not?
Sir.
Or which is the mens rea item here?
Guilty of mind, option C. Guilty of mind, sir, option C.
Option C, guilty mind and wrongful act. Yeah, both are thing. Good. We need not to check again because we know it. Next question. Provision for the right of private defense is given between the dash IPC. Okay. I think you can shoot it, this one.
Section B, sir. Option B, section
Yes.
96 to
In this one it will come. Option B is right answer. The consent is not valid consent under section 90 of the IPC. A, if given under the fear of injury or misconception of fact, okay, it will be given by a person of unsound mind, okay, if it given by the child below the 2 years of age, and all of these. I think all of these will come.
Yes, sir. Option D, all of these correct.
Because as my knowledge goes, so this is the... So causing the death of a child in the mother's home is not homicide as provided in the explanation 3 to section 300, B explanation 3 to section 299, and C explanation 3 to 301. Because with my mind I can shoot is the B answer. Am I right?
Yes, sir. B is right, sir.
Because to my knowledge I'm shooting. Yeah? So this is that is the 37 question. This is, let us check it. Yeah, I think we are right. 37 question. 37A is the, no, he said, I think it is a jumbled order, it seems. 37A.
Sir, 36, sir. That question is 36B.
Okay, that is question is 36. Okay. And here it also jumbled because he changed it from... So, see, machine learning changing is different and human changing is different. Human will not commit a mistake, but a machine will commit a mistake. How could a robot argue in the court of law? It will argue only those things which is feeded. But if it is asked in a different style, it cannot argue. Is it clear?
Yes, sir. Yes, sir.
So, which of the following law, according to the Article 13 Indian Constitution, rule, custom, usage, I think, is it bylaws?
I also wrote bylaws, but according to key, it is none of these.
Is it? My goodness.
I wrote bylaws option B, sir.
Oh, no matter. Only 8 marks you lost. Okay, 39th question. Which of the following schedule deals with the union list, state list, and 7th schedule?
Sir, option A, 7th, it is very known question.
Can he ask so easy question? No, they are not supposed to ask so easy questions. Okay, under section 82, 83 of the Indian Penal Code, an offense punishment is done by a child.
Such easy questions we thought again and again, sir. We think again and again any twist is there. In simple questions, we think again and again, sir.
Yes. Because generally, no, they put something not or in or out or something, they will make it a negative. So it doesn't matter. Yes, we have to think it again. It's always good. Okay, this is I think the below 7 years it is. 40th question. B answer with B means above 7 years of the, but below the 12 years having attained the sufficient maturity and understanding.
Yes, sir. Insufficient maturity.
Okay. I did not gone through. See, overconfidence. No, I did not gone through it. I saw here below 7 years. But anyway, doesn't matter. See, getting 40 question is only a little finger business. Only little finger business. Not even the middle finger business or thumb. So section, this is also very easy. Section 125 of the Criminal Procedure Code of the secular in character was observed in the which of the following case law? Mohammed Ahmed Khan versus Shabano Begum. Am I right?
I don't know, sir, answer.
No,
Yes, sir, you're right.
the first time history, a Muslim will get the maintenance only with this case law. Otherwise,
Okay, sir.
there is no sensation in the India in the world. I am speaking. There is no sensation in the world. So 41th question C. That is the reason I can know 41 question C. Yeah. It is a sensational case law. The first time maintenance is given for the Muslim women. Otherwise, CRPC 125 give only for the Hindus. Is it clear?
Yes, sir. Yes, sir.
Muhammad Ahmed Khan versus Shabano Begum case law. Yes. And who has the power of summary trial of a case? Okay. I think the practicing
I
advocate,
wrote it as C, sir. Any magistrate of first class specially empowered by the High Court. I wrote as C. But according to the key, it is wrong.
What is right?
All of the above.
I have not read the Chief Judicial Magistrate, Metropolitan Magistrate, anywhere. If you read, no, you will have an idea. All of this above is the right idea. But it doesn't matter. Only 9 marks you lost. And out of 8, 100 marks, only 9 marks. Very good. Which section deals with the process to compel the appearance of the Code of Criminal Procedure 1973? This I don't know. I can shoot it. You see, I don't know the answer, but section 69 to 90, B section 55 to 173, section 210 to 219, B answer. Is it?
I think it is C, sir.
43A it is written.
Okay.
43A means section 61 to 90. So I am also wrong in shooting. It is A. Okay, now 44th question. An offense of which a police officer may arrest a person without a warrant, cognizable offenses.
Very easy question.
Assault or criminal force to woman with the intent to outrage her majesty under the IPC in which kind of offense? Outrage offense is a cognizable and is a non-cognizable offense.
No, sir, I wrote it as cognizable and bailable. But
okay, now let us see. Assault on criminal force to a woman with intent to outrage her modesty of IPC is which kind of offense? It is a cognizable offense and non-bailable.
Yes, sir.
Because if you just read it, no, you can understand it. That what actually it is. Yeah.
I wrote it as cognizable but non-bailable.
Yeah. A placeman for the firearms and the outlets the building to tell Z that they will be fired at the Z if Z attempts to leave the building. A is guilty of wrongful confinement, wrongful restraint, both wrongful confinement, wrongful restraint, none of the. But let me read. A places man with the firearms at the outlet of the building of and tells Z that they will fire at Z if Z attempts to leave the building. Okay.
Sir, option A, wrongful confinement.
Yeah, I know. See, both wrongful confinement and wrongful restraint it is.
No, sir, only wrongful confinement. Restrain. Check.
40,
I wrote it as
46 is to my knowledge. 46 A. 46A is the right answer. Wrongful confinement, they say. See, in the wrongful confinement, no, he confined to all the places.
Restraint is abstracting from
restraint
all
means
the
going from one side. But when you say confinement, you need not to write wrongful restraint here. Wrongful confinement means he cannot move anywhere.
Yes, sir. All sides he is locked.
Yes. And wrongful restraint means not going to a particular place. I don't think I applied very without applying the brain. Wrongful confinement already there here. Wrongful confinement means totally confinement. When you say totally confinement, there is no question of appearing in the wrongful restraint. Okay, it doesn't matter. Okay, because even myself also commit a mistake because of overconfidence also. So that's why we have to read thoroughly. Okay, the provision of the plea bargaining, I think we discussed this plea bargaining in the CRPC, not applicable to the offences committed against the child below the age of. When you say child, generally the definition of the international is concerned below the 18 years. International I am speaking.
Your answer is 14, sir. B.
But in the factories, they say 14.
Yes, sir. In previous question, sir, age between 7 to 12 years who is understandable, he is punishable, no?
Yes, yes.
In that way, I wrote it as A, but the answer is to B.
Okay, but generally, in the labor laws are concerned, 14 is considered.
Yes, sir. In Factories Act, in Companies Act, labor laws, all shows 14 years.
Okay, doesn't matter. See, we have to get the 40 marks, and no one is going to give the reward to us if you score 90 marks. But it is our self-satisfaction. It is
Yes,
our
sir.
self-satisfaction. That is more important.
Yes, sir. Yes,
Yeah,
sir.
if someone lies before the court an affidavit, okay, how it can be tackled by the advocates? No, if someone lies before the court an affidavit, how it can be tackled by the advocate? A, perjury application can be filed.
Sir, I shooted it as A, perjury.
Because I don't know, because it's purely the.
Sir, just I guessed option A.
Perjury, I don't know, because withdraw from the case, file the application to support that, pay fine. I used to say it C. Okay, doesn't matter. And now 49th question, proclamation of a person's absconding shall be published as follows. A, 1, 2, 3, 4. Oh, it shall be publicly read in some conspicuous places of the town and village in which such a person ordinarily resides. Yes, it should be a must. It should be affixed in some conspicuous part of the house or homestead in which such a person ordinarily resides, or some conspicuous place of such a town and village. Yes, a copy there shall be affixed to some conspicuous part of the courthouse. I don't think whether the courthouse also come into the picture.
Yes, sir. All are correct, sir.
Okay, and okay, then all are correct is the answer. Because I got the doubt whether court premises also comes under or not.
No, sir. I saw in the book, sir.
Okay, so 49th question, D is the right answer. 49th, yes, you are right. D is the right answer. Because I doubt about the court, but I know the residence areas where he'll make it out, but the court I don't know. Okay, let us good. In summons, a trial can instituted on a complaint where the summons has been issued, the accused non-appearance, death of the complaint and shall entail discharge of the accused, acquittal of the accused, either discharge or acquittal respecting the fact and circumstance of the case, and none of this. Why this? Suppose the complainant died, I don't think the discharge of the accused will come. No, is there none of the above 50D. Oh, 50B. Approach 50B. What?
Acquittal.
In summons trial, case instituted on a complaint where the summons has been issued to the accused, and the non-appearance or death of the complainant shall entail acquittal of the accused. But accused itself is dead, no? Anyway, this is for me also confusion it is. But anyway, I can lose 1 mark, doesn't matter. Suppose FIR is not registered by the station house officer, we can make a private complaint to the magistrate. What are the options or the complaint has? We can write to approach the superintendent of police first, approach the magistrate by filing a private complaint second. None of this wrong. Both approach the superintendent of police and approach the D is the right answer. Am I right?
Yes, sir.
Because there are 2 ways. First, you can write to the superintendent of police. Suppose if he did not take up the issue, we can write the private complaint to the magistrate. Or we can do the both, because we have to act on the option which was given below, given there. Is it or not? So
Yes, sir.
anyway, 52 question. Any police officer making an investigation under section 160 of the CRPC cannot require the attendance of the male at a place other than the place of his residence who is, okay, under the age of 15 years and above the age of 60 years, under the age of 18 years and above the age of 60
Sir,
years,
option C.
under the age of 15 years, above the age of 65 years, under the
Yes,
age
sir. That
of,
is correct, sir.
I would have to shoot either C or A. But A,
Sir,
no.
C is right, sir.
C is right because here 60 years. Here age is more, no? And his age is less here. So here
Yes, sir.
age is more, his age is less here. So naturally the age is more, the people will not ask them to come. The people will go. Okay, now next question. Mr. X and Y and Z are joint and severally liable for the 10,000, okay, degree obtained from the A, Mr. obtained the degree of the 1,000 against the B against the place the execution of the court in which joint decree being executed, which of the following option is correct, Mr. A? A may treat this joint decree as a cross decree under the Article 21, 21, Rule 18.
Sir, B is right answer, sir.
B
right, sir.
Which one?
B, sir. Mr. A cannot treat his joint degree as cross degree under Rule 21, Order 21, Rule 18.
No, I lost the point. I was not thinking about that one. But anyway, the B is the right answer. Okay. The A and B are the co-partners of joint Hindu family. They jointly execute a mortgage in favor of the Y. Y file a suit against all of them. Summons is served to C but not to ABC. None of them appears and an ex parte degree is passed against all. AB applied for the set aside ex parte degree. The degree shall be set aside against who participated? The degree will be set aside only those persons
C,
or all
A, B, C. C, A, B, C, all.
Means the degree will be set aside for all of them if any one of also not present over there.
Other co-person is only he had sent the notice summons to the C only.
Okay.
All are equal. All are having equal rights. Then case is set aside.
Okay. This also I did not have knowledge. Which of the following provision of the Civil Procedure Code 1908 deals with the institution of the suit? I think 22.
Section 24.
Okay, 24 is the right answer. Okay, institution of the suit. Okay, defendant shall within dash of the days from the date of the service of the summons on him present written statement his defense order say. Is it 30 days or no? 15 days only, no?
Sir, 30 days, sir.
Is it 30 days?
Yes, sir.
Okay. So here also I committed a mistake. So which of the following statement is incorrect? First appeal can be on question of fact or law or both. The second appeal can be on substantial question of law only. The second appeal cannot be on question of fact or law both. Second appeal comes when there is a question of law appears. Am I right? The first appeal may or may not be in the High Court.
Yes, sir. Yes, sir.
The first appeal may not be in the High Court. Second appeal has to be in the High Court. No. Question of law is there. Yes. And which order of the Civil Procedure Code deals with the temporary injunction and interlocutory injunction? Order 41.
Yes, sir.
Right?
Yes, sir.
Okay. I need not to check. Okay. A is a tradesman in Ahmedabad. B carries a business in Delhi. And his agent in Ahmedabad buys a goods A, requests A to deliver them to the Western Roadway Transport Company. A delivers the goods according to the Ahmedabad. A may sue for the price of the goods. A is in Ahmedabad only, in Delhi only, in either Hyderabad, Delhi. Now the law is changed. They can file a suit anywhere, wherever there it may be. Is it? The two places. Am I right?
Yes, sir.
Either he can file a suit at the Ahmedabad or he can file a suit at Delhi. It is discretionary. but not anywhere in India.
Yes, sir.
59, yeah, 59 question, 59C. 59C means either in Ahmedabad or Delhi. Yes, I am right. Okay, which of the following section of Civil Procedure Code deals with the concept of res judicata? Easy question.
Yes. Sir,
This section?
section 11.
Section. I asked this question recently also.
Yes, sir.
Okay, when the liability of the person who is one of the parties to the suit depends upon the liability of the stranger to the suit, then admission by the stranger in respect of the liability shall be admission in the part of the person whose party is to the suit. It has been provided under the which section of the Indian Evidence Act 1872? Section 17, Section 18, Section 19, Section 21. Let me shoot it. Section 17. 61. 61. No, wrong. 61C.
Sir, I think it 19, sir.
19th is the right answer. Okay, here I also missed my chance. Judicial evidence means, I could not miss this chance. Evidence received by the court in proof or disproof of fact.
Sir, this is right, sir.
Evidence received by the police officer, never. Evidence received by the Home Department, never. Evidence received by the tribunal, never. So, answer is?
Yes, sir.
A is answer. Is a clear answer, no doubt at all. Which
Yes,
of the
sir.
following is not a document? Oh, Indian Evidence Act. Inscription of a metal plate or a stone, a map or a plan. I think the caricature.
Sir, what is meant by caricature, sir?
A drawing. Caricature means like a cartoon.
Okay.
The number one. Number two, caricature means skeleton.
Okay.
Skeleton of an animal.
Yes. Okay.
Skeleton of an animal is called caricature, and the skeleton of a man is called corpse. For dead body, we say living person, we say corpse. For the animal dead body, we say caricature. Is it clear?
Yes, sir.
For a man dead body, we can't say caricature. For a man dead body, we'll say corpse. For the animal dead body, we'll say caricature. Okay?
Okay, sir.
Yeah. Yeah, presumption as a dowry death is given 7 years, no? Under which section of the 113 A, B, C, D, A, B, C, D? Is it B? 113B? 64.
I think C, sir.
64. 64B.
Okay, sir.
64B. I am right.
Okay.
See, because I thought no, so my mind said no, this may be the right. Okay, sometimes I may be wrong, no doubt. Which of the following is not a secondary evidence as per the 63 of the Indian Evidence Act? Copies made from the original by the mechanical process would these themselves ensure the accuracy of the copy, and the copies compared with the such copies. Okay, copies made from a compared with the original account of the accounts the contents of the document given by some person who himself seen it. Copies not certified under section 63.
Sir, I am a little bit confused here.
Actually, it is a mechanical process. It is made. It is deemed to be the secondary evidence.
Yes, sir, I wrote the same, but I wrote the same A, but in as per key answer is D.
It's not certified by the under section 63.
Yes, sir, not question is not secondary evidence, sir.
It's not secondary evidence. Okay. Now I
Yes,
got
sir.
it.
In that way, it is
Yeah.
D is correct.
You have to concentrate
But
on
I wrote
negative,
it wrong,
not
sir.
secondary
Keep it
evidence.
as A.
Not, it is not at all a secondary evidence because it is certified by it.
Yes, sir. Yes, sir.
Yeah. We have to be very careful when the knot comes. I framed several knots in my last class, my
Yes,
last
sir. Yes,
teaching.
sir. That time
Several
I
knots.
shooted it as wrong.
Yes, as per the
I
order,
shooted it as A, sir.
yeah, as per the order 6, pleading shall mean plaint, written
Options will both
statement.
plain and written statement. It is very
Yes.
simple.
This is the right answer. Right. You are right. You are right. What of the following oral order deals with the death, marriage, and insolvency of the parties? I don't know. Yeah, I can shoot it whether Article Order 21, 16.7, Order 21B, 67C. No, I'm wrong. It is a C answer. Means Order 22 is the answer. Okay, the doctrine of regeste has been discussed with the section of the evidence. This two times asked. Is it not?
Sir, that is res judicator. This is res gesta.
Okay, res judicator. No, that is a okay. Regeste which section?
I think it is section 6.
Section 6. Okay, 68B. Yeah, 68B. 68. Yes, you are right. 68B. Section 6 is educator. That is registered.
This is res gesta, sir. Section 11, sir. Res judicator, section 11.
Educator is estoppel is section 115.
Yes, sir.
Doctrine of estoppel. So, which of the following section deals with the arbitration agreement in Arbitration and Conciliation Act 1996? Okay, 6, 7, 8, 9. Section 9. Section 9. 69.
Section not asked here, sir. Final arbiter award, interim arbiter award.
Section 9B. This 7. Which of the following section deals with the arbitration agreement is Arbitration and Conciliation Act? B. The section 7 is the right answer. Under what circumstances the arbitral proceeding can be terminated? Interim award, final award, where the arbitral issues order for the termination, and A is 1 and 3, and 1, 2, and C 3, and D 1, 2, 3. Final arbitral award, okay, terminated. Okay, where the arbitral tribunal issues an order of the termination, yes, 1 by 3. 1, 3, A is the answer. Am I right?
Sir, I think it is 2 and 3. C.
No, 1 and 3. Okay,
The
let us
answer
see.
is, I think, the answer
me
is
see
D.
70. 70A. I am right.
Okay, sir. Okay, sir.
I am right. Because the final arbitral award, one thing, and next, when the terminated, where the arbitral tribunal issues an order for the termination. So I thought these are only the two. So I thought A is the right answer. Okay. So under Section 29 of the Arbitration Act and Conciliation Act 1996, arbitral proceedings with more than one arbitrator, any decision of the arbitrated tribunal shall be made by all
Majority
members.
of the members, sir.
Huh?
It is made by majority of
It's a
members.
majority of the members. It is. Okay, not 2/3.
Sir, D.
Okay.
That's why it is always been odd number, sir. Arbitrators.
Okay, yeah, that is correct. That's why there will not be equal numbers should be there in the sake like
Yes, sir.
division bench and full bench.
Yes,
So
sir.
the provision for the maintenance pendulite Hindu marriage and was given. Is it 24, 25, 23, 22, 23? 24? 72C. 72.
I think
See,
25.
I won.
Okay, sir.
72C, I won. See, I don't know that I shooted it just
Yes,
by looking at it. So the
Yes, sir.
mechanism is working.
Yes, sir.
So, a Muslim wife may sue for the divorce under the Dissolution of Muslim Act 1939, Section 2, if the husband has been insane for a period of, I think it is 2 years is enough, not 7 years.
Sir, your answer is right. But we discussed it. I remembered it as 7.
No, when you cannot be seen for the consecutive 7 years, yes,
sir.
it
Yes,
can be.
sir.
So I am good in shooting now.
Yes, sir. Yes, sir. 2 years is right, sir.
Because I remember because 2 years
Here
desertion
insane, sir.
also ground.
Here insane is there.
Yeah, 2 years desertion also a ground, a continuous. A leading question may be asked in examination in chief, cross
Examination, sir.
examinations, re-examination, but generally leading question should not be asked.
No, sir. In cross examination, it is there, sir.
Is it?
Yes, sir.
74C. Oh my goodness. I am
Yes, sir. In
failing
cross
here.
examination, leading question may be asked.
Okay. I say in any case you should not ask it. So especially in the cross examination you should not ask it.
Yes, sir. Yes, sir.
Okay. Right. Here I lost that. I was thinking they are not supposed to ask in any place. It's an extrajudicial confession means confession
Sir,
made either to
sir,
the
option
police,
confession
police
made either
and
police
confession made to
person
the
or other
magistrate,
than
confession
magistrate.
made before judges, none of these. To me, is none of this.
No, sir. Option A, sir. Confession made either to police or
Confession made to the police officer will not be deemed.
this is extrajudicial, no, sir.
So it's an extrajudicial other than the judge and magistrate. Okay, extrajudicial we can say. Right. You are right. The arbitral tribunal shall not be bound by dash in the determination of rules of procedure. The procedure generally shown in the civil procedure and the Indian Evidence Act, the Code of Criminals. No, arbitration is purely civil. And both the Code of Civil Procedure and Indian Evidence. I think because why this man gave like this means there is something wrong is there. Am I not? Why this man has given both the Civil Procedure and Indian Evidence Act. That gives the sense that only not the Civil Procedure Code alone. So the right answer is either A or B.
I wrote it as B, but according to it is D.
Indian Evidence Act. Okay, I also lost the mark here. Okay, which one of the following is not a ground for divorce in Hindu Marriage Act? I think we dealt it already, this thing. Not.
Sir, option D, living separately for less than 3 months. It is very clear.
Yeah, because it is a living together more than 2 years, desertion, not be seen for the 7 years, that is the ground. So Indian Christian can be divorced. We already discussed this thing yesterday. Is it not Christian Marriage Act? Because inheritance in the Indian Divorce Act. Okay, the section 12 of Hindu Maintenance and Adoption 95 deals with the right of we also dealt it, effect of adoption.
Yes, sir.
It is effect from the adoption, that is section 12 of the Hindu Marriage Act. Yesterday we dealt it. And which of the following categories cases will not be entertained by the public interest? Yes, this is also there. This is a disputed question. Actually, it is both land and matters and family pensions.
Yes, sir. I wrote it as family pensions.
No. Actually, first and foremost, you are right. Land tenant matters. Later on, you can write the family pensions. But how could you know that later on and beginning? Hence, the marks will be given to both of them.
Okay, sir.
The marks will be given to the both of them. Otherwise, we can challenge it in the court. But he has to write the question in the recent judgment of the public interest litigation. Which one is tackled? Means landlord and tenant. That is the answer.
Okay.
Who is known now? This is Justice Bhagwati. Everybody knows. Muslim woman has an opinion to be governed by the provision of the 125. Yes. Again, it comes. Somebody says section 7. Somebody says section 6. If you happen to see section 5, 6, 7, I don't think this is relevant. Because somebody gave the explanation. Sir, it is section 7 is there. You check the section 7 of the criminal, the Muslim Women's Protection Right Act, only 7 sections are here. I will show you now. Only 7 sections or 6 sections are here. Among them, nothing is covered over there regarding the maintenance is concerned. See, this is the Women's Act. Protection of right now. सारे जहां से अच्छा हिंदुस्तान हमारा, जय हिंद।
ख्वाब तो सिर्फ कश्मीर की आज़ादी के आते हैं।